Good day, guys, especially to my students in BS Criminology. Welcome again to our YouTube channel, Criminology Made Easy. What I will discuss today is one of the topics in the Philippine criminal justice system, which is the preliminary investigation. So, to begin with, my order of presentation will be the nature, purpose, procedure of the preliminary investigation in the Philippines, and some innovation arising out of the COVID-19 pandemic, okay, in the preliminary investigation. So, if a person is arrested, what is the purpose of delivering him to the nearest police station or jail and detaining him in that place? So it depends. So if the arrest is with warrant, the arrested person must detain for him to face the case that is already filed against him, or to serve his sentence if he is already convicted. However, if the arrest is without warrant, he must be detained to undergo an inquest proceeding or preliminary investigation. Okay, so when we say inquest proceeding is it is a proceeding done by the inquest prosecutor to determine the validity of the warrantless arrest. Okay, so that is an inquest proceeding is a very summary in nature, which may be done by an informal interview with the arresting officer and or the arrested person. Okay, so whereas when we say preliminary investigation, so a preliminary investigation is an inquiry held for the purpose of ascertaining whether or not probable cause is present. So it is intended to secure the innocent against hasty, malicious, and oppressive prosecution, and to protect him from an open and public accusation of a crime. So in other words, in preliminary investigation, the very purpose of the preliminary investigation is to determine the probable cause. Okay, so now you may ask, what is a probable cause? Okay, so as provided by Section 1, Rule 112 of the Rules of Court, a probable cause is the existence of sufficient grounds to engender a well-founded belief that a crime has been committed and the respondent is probably guilty thereof. So if the probable cause exists, the respondent should be held for trial. So that is according to Section 1 of the Rule 112 of the Rules of Court. Okay, so meaning when we say probable cause, it is the legal basis. Okay, it is the legal basis that the crime is committed. So it must be further take note that the probable cause in a preliminary investigation and the probable cause for the issuance of warrant of arrest or a search warrant are different from each other. So a probable cause in a preliminary investigation is determined by the prosecutor. Okay, so while the probable cause for the issuance of the warrant of arrest or a search warrant is determined by the judge. Okay, so another one is when is a preliminary investigation is required? So a preliminary investigation is required when the imposable penalty for the crime charge is 4 to 1 na sinasabi natin, or the 4 years, 2 months and 1 day imprisonment without regard to fine. Okay? So another one is when you may ask again, when may an arrested person ask for a preliminary investigation? So a person may ask a preliminary investigation in any of the following. So number 1 is before the filing of complaint or information in court, or within 5 days from the time he learned that a complaint or information is already filed against him. So in asking a preliminary investigation, the arrested person must sign a waiver to renounce his right under Article 125 of the Revised Penal Code. Notwithstanding with the waiver, he may apply for bail. So Article 125 of the Revised Penal Code is the delay in delivery of the arrested person to the proper judicial authority. Okay? So you may ask again, who are the officers authorized to conduct preliminary investigation? So the following may conduct preliminary investigation. So number 1 is we have the provincial or city prosecutors and their assistants. Okay, judges of the municipal trial courts and municipal circuit trial courts, national and regional state prosecutors, and other officers as may be authorized by the law. Okay, so when we say other officers, so meaning dun sa ibang lugar, okay, to the far-flung area, okay, rather. So take note also that the authority to conduct preliminary investigation shall include all crimes cognizable by the proper court in their respective jurisdiction. So as provided by Section 2, Rule 112 of the Rules of Court. Okay? So now we are now moving on the what is the procedure in conducting preliminary investigation. Okay? So with regards to the procedure of conducting preliminary investigation. Okay? So first is a filing of a complaint. So the number 1 step is a filing of complaint. So a complaint to be filed shall be accompanied, okay, by the affidavit of the complainant and his witnesses and other supporting documents to establish probable cause. So in filing a complaint, of course, there is a specific, okay, number, okay, of complaint that must be filed. Okay, so now you may ask, what is the number of copies of complaint? Okay, so of course, if there are of course, if there are 3 respondents, okay, the number of complaint must be 5. So the two copies are for the official file, okay, or yes, for the official file of the court. Okay, so now another one is dismissal of the complaint or the issuance of the subpoena by the investigating officer. So that is the next step. So within 10 days after the filing of complaint, the investigating officer shall either dismiss the complaint if he finds no grounds, okay, to continue with the investigation, or to issue a subpoena, okay, to issue subpoena to a respondent attaching to it a copy of a complaint and its supporting affidavits and documents. So take note that a copy of evidence may be furnished to the respondent at its own expense. So object evidence need not to be furnished to the respondent, but shall not avail, or shall be available for examination, copying, or photographing. So at the expense of the requesting party. So the next step is submission of counter affidavit. So in the submission of the counter affidavit, it is 10 days from the receipt of the subpoena with the complaint and supporting affidavits and documents. The respondent shall submit his counter affidavit, okay, and of his witnesses and the other supporting documents relied upon his defense. So in the submission of counter affidavit, okay, please take note that the respondent shall not be allowed to file a motion to dismiss in lieu of the counter affidavit. Okay, so you may ask, what if the respondent cannot be subpoena, or if the subpoena does not submit counter affidavit within 10 days period? Okay, so if the respondent cannot be subpoenaed, or if the subpoena does not submit his counter affidavit within the 10 days period of the investigating officer, okay, the investigating officer shall resolve the complaint based on the evidence presented by the complainant. Okay, so that is the rule. Okay, so another one is the next step is the clarification. So in clarification, it is within 10 days from the filing of the affidavit, counter affidavit by the respondent. The investigating officer may set a date for hearing if there are facts and issues to be clarified from the party or a witness. The parties can be presented at the hearing, but without the right to examine or cross-examine. So they may, however, submit to investigating officer questions which may be asked to a party or a witness concerned. So take note that in clarification shall be terminated within 5 days. Okay, so kindly take note on that. So another one is the issuance of resolution. Okay, so take note that the ones issued by the prosecutor is a resolution, not judgment. So a resolution is to be issued within 10 days from the termination of the investigation or clarification. So after the investigation, the investigating officer shall either prepare a resolution and information if he finds cause to hold the respondent for trial, or recommend the dismissal of the complaint if he finds no cause to hold the respondent for trial. Okay, so you may ask, if the information is issued, what is or what must be certified by the investigating officer? Okay, so if the information is issued, the investigating officer shall certify under oath in the information the following. So number one is that he as shown in the record, an authorized officer has personally examined the complaint and the witnesses. Okay. Second is that there is a reasonable ground to believe that a crime has been committed and the accused is probably guilty thereof. And third is the respondent was informed of the complaint and the evidence against him. Okay, and lastly is that he was given an opportunity to submit a controverting evidence. So those are the information, okay, or yes, those are the things that must be certified by the investigating officer. Okay, so the last one step is transmittal of records of the case. So the transmittal of the records of the case is within 10 days from the resolution. The investigating officer must transmit the record of the case to the provincial or city prosecutor or a chief state prosecutor, or to the ombudsman or his deputy in cases of offenses. Take note, offenses cognizable by the Sandigang Bayan in the exercise of its original jurisdiction. So these officers will act on resolution within 10 days from the receipt thereof and shall immediately inform his parties of such action. So class, that is the procedure. Those are the procedure, rather. Those are the procedure. Okay? In conducting preliminary investigation. So now, we are now moving on the innovations arising out of COVID-19 pandemic with regards to the conduct of the preliminary investigation and hearing. Okay, so from the beginning of the March 2020, different parts of the Philippines were placed under the varying degrees of community quarantine to prevent the spread of COVID-19. Okay? Accordingly, the Supreme Court and the DOJ, or the Department of Justice, imposed several measures to adjust to the situation. Okay? So now, what are the innovations arising out COVID-19 pandemic? Okay, so we have the electronic because of the by virtue of administrative order, okay, issued, or administrative circular rather, issued by the Supreme Court. Okay, one of the innovation is electronic court filings and hearing through video conferencing. Okay, so it was by virtue of Administrative Circular Number 33-2020 on March 31, 2020. So the Supreme Court issued or allows the following. So number one is the Supreme Court allows the filing of course, the filing of information via mail. Okay, and second is it allows the DOJ or the Department of Justice to continue with the prosecution of individuals and the court to issue a warrant of arrest where needed. Okay, and then another one is another innovation under this administrative circular is allowed individuals to post bail and for courts to act as such a bail applications via electronic means. Okay, so another features of this administrative circular is that approval, okay, the Supreme Court approval of bails and release of orders, okay, are to be electronically transmitted, okay, to the law enforcement agency or detention facility where the applicant is detained, and the soft copies of the order are sufficient to cause the release of the said individuals. Okay, so those are the innovation under this administrative circular. Okay, so another one is the Supreme Court through the administrative circular number 37-2020 and the Office of the Court Administrator circular number 93 excuse me 2020. So according or by virtue of this administrative circular, the Supreme Court authorized the pilot testing of video conferencing hearings on urgent matters in criminal cases involving detained individuals. So eventually, video conferencing hearing were authorized for both criminal and civil cases. So kindly take note of that. Okay. So video conferencing by virtue of Administrative Circular number 37, 2020 and Office Court Administrator Circular number 93, 2020, okay, are authorized for both criminal and civil cases. Okay. So another one is online alternative preliminary online alternative methods for preliminary investigation. So recently, in the Office of Order dated June 1, 2020, the Department of Justice issued an alternative procedure for preliminary investigation during the public health emergency. Okay, so under this office order, which was dated June 1, 2020 by the Department of Justice, these procedures is necessity for the face-to-face preliminary investigation hearing. Okay, so a face-to-face preliminary investigation hearing before the public prosecutor has been stopped. So parties simply subscribe to their complaint, affidavit, or counter affidavits before the police or any prosecutor on duty, and of course submit the same electronically to the public prosecutor handling the preliminary investigation, to be followed by the hard copy submission. Okay, so under this office order, okay, also if the public prosecutor wishes to conduct hearing to obtain greater clarification, they may resort to video conferencing. Okay, so however, as to the electronic inquest rules, these rules are optional, and their implementation depends on the particular prosecutor's office capabilities. Okay, so that's all guys, class. Okay, especially to my student in BS Criminology. I hope na meron kayong kahit papano ay meron kayong natutunan sa video na to. Okay? So again, thank you, and of course, don't forget to subscribe, subscribe our channel, Criminology Made Easy. Okay? So again, thank you, and good day.